Good afternoon, everybody. I'd like to call this meeting to order, this special Senate meeting. Before we get started, there's a motion to approve the following special rule. Each speaker is limited to 2 minutes each time they're recognized. Host, if you could unmute, we'll ask for a second to this motion. Is there a second?
Second.
We could initiate the poll, please.
You have about 10 more seconds to vote. And last call. There being 114 ayes and 4 nays, the motion prevails.
Thank you, Chris. Okay, welcome everybody. It's good to see you virtually. I thank you all for your time and energy on these important issues that we have before us today within the Senate, in our entire community, in the daily work that you do. There's a lot going on. And what I mentioned in my email at the end of last week would normally be the quiet time of the summer. It is anything but, and we have lots of really important work to do. I'm glad we have the opportunity to do this, although I will reiterate what I said in my email, which is I hope that you're also, as much as possible, taking time to rest and recharge. I know we all need it. We all need it. So a couple of notable issues that I want to call to your attention as we get started. First of all, I would be remiss, you will be receiving an email probably while we're in this meeting that's going to update you on our mask policy. It will reflect that we have what we've called within the administrative team gracefully pivoted. Forgive me for assigning such a positive adjective to our own work, but we are pivoting to now require masks indoors on campus. I know this has been a major concern in our community. We have been tracking with the recommendation from different public health groups and guidance and the research and the science, and it has evolved to a point where we feel comfortable aligning with it and making that requirement. So you'll see that email while we're in this meeting, I suspect, and some frequently asked questions. So there's both a protocol for what the expectations are and frequently asked questions with answers. As the science evolves, so will that protocol, but that's where we are now. We also have a Board of Regents meeting on July 8th and their retreat on July 9th and 10th. And there will be a couple of key issues that come before the board. Everything that comes before them we think is pretty key, but a couple that might be particularly interesting to this body. The first is that we will be taking action on a retirement incentive option, or RIO, with a discussion ensuing from that. If you're interested in that, you may wish to tune in for that, and I'll send a summary afterwards. We'll also be taking action on this Title IX work that we're doing today, as to be determined based on the outcome today. And then the last thing that I want to make this group aware of is I'm also asking the board for more time before we take up for action the renamings policy that many of you have consulted on and that we've been working on together. We came pretty close to having a renamings policy ready for the board to adopt. As you may recall, this is board policy. The names of buildings is board policy, but they asked the administration to steward a consultative process to develop a renamings policy after the work that was done with great appreciation to the faculty who participated last year. But speaking specifically for myself, my reflection in the last few weeks makes me really think about the policy in the way we phrased it, the processes that it employs, and I want with you in a consultative way to be able to reflect and reevaluate and do more consultation. A lot has happened since the original charge from the board to consider a structure for renamings. This is an effort to get better at this so that we do it right. And so I appreciate the time we would expect it to come back up again at when it was originally scheduled to, which is September, when the governance committee of the board meets again. So we'll do a lot between now and then, but I didn't want that to surprise anyone. So now with that, we'll turn to our first item on the agenda, which is a discussion on changes needed to bring the university into compliance with new federal Title IX regulations. So as I'm sure you all have been tracking, last month, the Department of Ed, the US Department of Ed, issued final Title IX regulations that will take effect on August 14th. Timing is amazing, but here we are. The new regulations specify how institutions must address reports of sexual misconduct that are covered by Title IX. The federal government's mid-August deadline leaves us an unbelievably short window in a very challenging time to revise our policies, procedures, and practices. We are committed to doing so in a way that is informed, consultative, reflects the needs of all parties involved. And with that, I will turn it over to Tina Marisam, our EOA Director and Title IX Coordinator, and Professor Ned Patterson, incoming Vice Chair of the FCC, who will present this item. Thank you.
Thank you very much, President Gable. And good afternoon, everyone. I'm going to share some slides on my screen. All right, hopefully you all can see that. So Ned Patterson and I wanted to take a few minutes to summarize some of the key changes that are being proposed to university policies to bring them into compliance with these new Title IX regulations. And then we hope to leave a lot of time for discussion and to solicit your input and feedback. So currently, the university applies somewhat different grievance procedures in sexual misconduct cases, depending on the classification of the respondent. That is, the grievance process is somewhat different depending on whether the respondent, the person who's been accused of sexual misconduct, is a staff member, a faculty member, or a student. And you can see on the slide a list of the policies that contain these different grievance procedures. Currently, none of these procedures are compliant with the regulations. And so we will need to take some action to all of these policies to bring them into compliance. Our proposal is that we bring these policies into compliance by adding some language to them that states that sexual misconduct matters will be addressed under the administrative policy and procedures on sexual harassment, sexual assault, stalking, and relationship violence. This would create a single sexual misconduct grievance process for all university members, students, staff, and faculty system-wide. And we see some advantages to having a single grievance process. First, to avoid the duplicative efforts that would be needed to create and run different hearing processes across campuses and across employee classifications. We also think a single process will promote fair and consistent outcomes in sexual misconduct cases across university populations. And it will also enable better oversight in an area that now needs to meet fairly detailed and technical regulatory requirements. So the regulations require that the university apply either the preponderance of the evidence standard or the clear and convincing evidence standard in all sexual misconduct cases. So to make a policy violation finding under the preponderance standard, the decision maker needs to be convinced that the reported conduct more likely than not occurred. That is, that it's more than 50% likely that the reported misconduct occurred. More evidence is needed to make a finding under the clear and convincing standard. Under that standard, the fact finder needs to be convinced that it's highly probable that the reported incident occurred. Currently, the university uses the preponderance of the evidence standard in all cases under our sexual misconduct policy to determine whether it was violated or not. We also use the clear and convincing evidence standard when discipline is imposed under the faculty tenure policy. Under the regulations, to comply, we need to select a single standard, and the draft revised policy proposes applying the preponderance of the evidence standard in all cases. This will require a change to the board policy on faculty tenure, which Ned is going to be providing some information about. And before I turn it over to Ned, I'll just say that it is a great credit to Ned and also the numerous other faculty governance members that have been able to consult with such a wide variety of faculty members and governance groups in such a short time period to put together this proposal. That's quite extraordinary. All right, Ned, here's your first slide.
Okay, thank you, Tina. I want to thank you, Tina, and Brian Slovett, the Deputy General Counsel, for all of your painstaking and amazingly detailed work. It's a lot of work. I don't envy all the work you had to do. So this proposal that you see in the docket to bring in the tenure code into compliance was approved by the Senate Consultative Committee last Thursday as a docket item for discussion today. And then there'll need to be an advisory vote to the Board of Regents, which would take place later at a special meeting of the Faculty Senate, which I will get back to. And I want to thank faculty, staff, and colleagues, student colleagues, for joining us today. And now I'll summarize the details. Next slide, please. So as Tina had mentioned, in appeals by faculty where they contest a finding from EOAA in 14.3 of the Judicial Committee hearings in the Board of Regents policy and faculty tenure, it indicates the clear and convincing evidence standard. And then, as you note, all of this is in sections 10, 14, and 15. And even though it's in the tenure code, it applies to all faculty, tenured, probationary, or tenure track or term in the code, which is contract faculty, just as 4.5 in the financial stringency and the salary reduction applied to all faculty. So even though it's in the tenure code, or the tenure policy, I should say correctly, it applies to all faculty. Next slide. So far, based on consultation to date, there's a general consensus from many faculty, staff, and students for the preponderance of the evidence, and that is what Tina and we are proposing. Given that, there are two options for amending the tenure policies. One is to make extensive changes in the policy sections of 10, 14, and 15. This would take a lot of work and would leave it all in the tenure policy, but would be really difficult under such a short period of time. Option two, which is the one we are proposing, is to carve out sexual misconduct in the tenure policy by adding a section 10.4. Next slide, please. I'm sorry, back to the previous slide. I'll have just a little bit more. Section 10 of the tenure policy is about leave of absence and also disciplinary actions, including those related to sexual harassment. And the section goes up to 10.3, and it includes potential suspension, termination, and also minor disciplinary actions. So the option two is to carve out an exception by adding a 10.4 just after 10.3. So that's the one we are proposing, option two. Next slide, please. As you can see, tenure code sections amendments are amended by the Board of Regents, but the process, as indicated in the tenure policy, is that proposed amendments from any source will be submitted to the Faculty Senate, which is what we're doing right now, for advice and recommendation before final action by the Board of Regents, which will probably be in a special Board of Regents meeting later in July. The Faculty Senate will solicit recommendations of the Faculty Affairs Committee, the Judicial Committee, and the Academic Freedom and Tenure Committee before giving its advice and recommendation, which we have already started. So our consultation to date, normally an amendment to the tenure code would be done in a slow and deliberative fashion, not during the summer, as President Gable mentioned, when governance activities are generally on hiatus. But as we can see, they don't have to be on hiatus. The need for action and changes is urgent, as you've seen. So we are attempting to compress through thorough deliberation into a shorter time span without sacrificing full consultation. So there's been robust consultation in the last month, as indicated in the docket and accompanying materials. This includes, but is not limited to, the three committees on the slide here: the Senate Consultative Committee, the Faculty Consultative Committee, the Minnesota chapter of the American Association of Unity Professors, AAUP, University of Minnesota Leadership, and a working group of faculty with extensive governance experience, and then also a work group convened by Tina of administrators, faculty, staff, and students. Next slide. So here's my last slide. This is in your docket material. So this is again to carve out by adding a new 10.4 right after 10.3. And then it indicates here, notwithstanding other provisions in these regulations, the process for decisions and appeals regarding disciplinary action in response to complaints against faculty related to the Board of Regents policy, and then under this administrative policy that Tina will get to next, as a carve out, adding section 2.10.4. And at the end, we are recommending the administrative policy will provide either that a faculty, party, complainant, or respondent will have the opportunity to select at least one member of the hearing panel, or that there will be a faculty member on the hearing panel if a faculty member is a party. We wanted the either or to ensure flexibility, but also to ensure a faculty member will or can always be on the panel. In the current system, there's a whole panel of the Senate Judicial Committee of all faculty members for a faculty respondent. And we wanted to make it flexible where if an administrative policy or tenure policy could be changed in the future if needed, if there's future changes by the courts or a new presidential administration makes new policies. And lastly, and importantly, we want flexibility within this with this either or option for fairness and equity across all staff and students to ensure staff and student processes can be either very similar or the same as for faculty. And that's what I have to present. I think Tina will finish up and then we'll be open for discussion.
Thanks, Ned. So we wanted, before we finish up our presentation, we wanted to cover two additional proposed amendments to our policies and procedures. So the regulations require that we provide a live hearing before a decision is reached in all sexual misconduct cases. We currently do this already in cases with student respondents, but now need to do so as well in cases with employee respondents. What we propose is creating a system-wide hearing committee that will have members who will serve as decision makers in these live sexual misconduct hearings. That is, the community members would serve as panelists at the sexual misconduct hearings, and their role would be to determine whether the respondent violated the university's sexual misconduct policy. The hearing committee would be comprised of well-trained faculty, students, and staff from all employee classifications, and also from all 5 university campuses. In each sexual misconduct case, the panel would have 3 members. One would be a professional hearing officer, someone who had as part of their university job the responsibility that they serve as a hearing officer on these panels. And it would have 1 panelist selected by each party from a list of the available hearing committee members. So that would permit, for example, as Ned discussed, that if there was a faculty member party, that faculty member party could, if they wanted, select a faculty member panelist to be part of that panel of decision makers. Similar, if there is a student party, that student could select a student panel member or a panel member of a different classification. So in all cases, that 3-person panel would make the determination on responsibility of whether the respondent violated the sexual misconduct policy. In cases where there are student respondents, the panel would additionally make a determination on disciplinary sanctions, if any. In cases with employee respondents, the panel would make that decision on responsibility and would also make recommendations about disciplinary sanctions to either the dean or vice chancellor in cases involving faculty respondents, or the vice president or equivalent person in cases involving staff respondents. So finally, the regulations require that we offer an appeal process for all parties. And so the final amendment that we want to discuss is the creation of an appeal process for complainants and respondents in all sexual misconduct cases. We currently offer an appeal process already in student cases, but not in employee cases. So under the regulations, we're required to offer appeals based on the first 3 bullets on the slide. So based on procedure irregularity that affected the outcome of the matter, based on new evidence that wasn't reasonably available at the time the determination was made that could affect the outcome of the matter. Or because the Title IX coordinator or investigator or the decision maker, either on responsibility or discipline, had a conflict of interest or bias. So those are the 3 grounds we're required to offer for appeals. In the amended policies, we propose adding 2 additional grounds for appeals, those final 2 bullets. The first being that the decision was unreasonable, i.e. arbitrary, in light of the information presented. And finally, that the sanction was grossly disproportionate to the offense. And we do have discretion as an institution to include these final 2 grounds for appeal, to not include them, or to edit them. And we would really like feedback on that question. And then finally, the revised amended policy currently states that the following individuals will serve as appellate officers for students and faculty on the Twin Cities campus, the provost or designee; for staff on the Twin Cities campus, the vice president for human resources or designee; and for faculty and staff at Crookston, Duluth, Morris, and Rochester, the chancellor or designee. So that's the basic information that Ned and I wanted to share. So I will stop here, and unless Ned wants to add anything additional, open up for questions, comments, and feedback. And we're happy to talk about any of the information we presented or any of the other changes in the draft policies.
Thanks, Tina. I would like to add just one thing. I'd like to call on Fred Morrison, who was part of the faculty working group and has an extensive history in faculty governance in the tenure policy, and he's a former FCC, SCC chair. And Fred, would you like to make any comments?
Hello?
Yes, we can hear you, Fred.
Okay, you can hear me. Good. As perhaps some of the members in the Senate know, I was very involved in the establishment of the current set of tenure regulations. That was 25 years ago. And we were at that stage opposing some changes that would have weakened tenure very much. We succeeded in that effort. We are now faced with a very different kind of problem. It is a problem of making making our regulations consistent with what is going to be a national standard. I see this as a step forward. I want to say that I endorse it. I may have one little tweak to give to one little thing there, but it's just a technical matter. So I want to say that I believe this is a sound move in the right direction. Thank you. Unless there are questions.
Are there any questions for Fred? Okay, thank you, Fred. Really appreciate it. Chris, are there questions in the queue?
We do have one so far. Janice Conway-Clausen has a question.
Hi, Janice. Please go ahead.
Yes, Janice Conway-Clausen, faculty senator from the Center for Allied Health Programs. I was just wondering who makes the decision about whether or not the outcome of the hearing was unreasonable or disproportionate?
Thanks, Janice, for that question. So that would be once the decision is made at the hearing and after for responsibility and discipline, then each party, the complainant or respondent, would have an opportunity to appeal on those 5 grounds, including the 2 you mentioned. And that would go to the appellate officer, who differs depending on the classification of the respondent. So for example, on the Twin Cities campus, a faculty member appeal would be heard by the provost or designee. A faculty member on the other campuses, their appeal would be heard by the chancellor or designee.
Thank you.
Next question, Chris.
Next question is coming from Ruz Vukovic.
Hi, Rose. Would you go ahead, identify yourself, please, and then go ahead.
Yeah, my name is Rose Vukovic. I'm faculty in educational psychology and also a member of the Student Sexual Misconduct Subcommittee. so what I can't understand is the procedure that is being proposed, does it also change what's happening with students, or are they going to be separate processes, or are they the same process? Can you say a little bit more about that?
Yeah, thank you, Rose. Good question. What is being proposed is there would be one procedure for how hearings and appeals go that would apply to students and employees. And there would be one committee that provided panelists for panels across students and all employee classes system-wide. So essentially the hearing committees that are currently used on all of the different campuses and student cases would not exist in the form they exist in now. Panelists would instead serve on this system-wide hearing committee. And in part, this came about because we now need to offer live hearings in employee cases. And the kind of alternative would be to have different sets of hearing panels for employees and for students on all 5 campuses, being potentially 10 different panels, which could involve a lot of duplicative efforts.
Yeah, and currently the live hearing for the student committee is the appeal process. Like, so the live hearing doesn't have it, the appeal is the live hearing. So am I hearing something different, that there's an appeal, there's a live hearing and then you appeal that? Do you know what I'm asking?
Yep. So the live hearing currently in student cases and in in our proposal would be to determine responsibility, and then there would be appeal after that. And there is currently in our student sexual misconduct cases, there's a live hearing, and then each party can request an appeal of the decision that was made at the live hearing. So it wouldn't change from our student process.
Okay, I think I maybe just because my understanding is the EOAA makes the recommendation, and if the students appeal, that's when it goes to the live hearing, which is the committee I sit on. So I thought we were the first time that there was a live hearing, and it is after EOAA makes a decision.
Yeah, it is. Currently, there are 3 stages of review in student cases, and that will be the same now in student and employee cases. The first stage will be the EOAA investigation. The second stage will be the live hearing, and the third stage, should either party request it, would be the appeal.
Okay, thank you.
Other questions?
I did want to add in, we had asked because we need additional advice and consent or advice from the 3 committees. I'd asked the current and incoming chairs of the Judicial, Academic Freedom and Tenure and Faculty Affairs committees if they had any additional questions, comments, and then we need them to have some additional consultation to give advice back to the FCC and Senate. So is there any of those committee chairs that would like to speak?
This is Becky Used. I'd be happy to speak if there's time.
Go ahead, Becky.
Thank you. Becky Used. I'm incoming chair of the Senate Judicial Committee. And I do want to say I appreciate the leadership of Professor Patterson and many others over the past few weeks to support the committee's processes and the ability for faculty to bring cases to the committee other than for these Title IX stipulations. And I just want to reiterate again, the Judicial Committee hears cases after an action has occurred and the faculty member disagrees with the action primarily due to flawed processes. The original action may have been denial of tenure or promotion or a disciplinary action ranging from a minor sanction to termination. The Judicial Committee does not initiate an investigation to determine what happened, nor make a determination of a sanction. It is an appeal hearing for an action that already was imposed, and then the hearing panel makes a recommendation to the president. I feel that by adding this proposed paragraph, the other causes of disciplinary action listed in 10.21 of the Tenure Code remain, as does the hearing procedure. And for disciplinary actions, currently it's 5 faculty members hear the case, and then the dean has the burden of proving the case by clear and convincing evidence. For other cases brought before the committee, it's a preponderance of the evidence that is used for cases of denial of tenure or promotion. And for information, the committee is meeting this coming Monday July 6th to further discuss this matter so that we have more consultation before the mid-July Faculty Senate meeting. Thank you.
Thank you, Becky. Any other comments or questions?
I think we can wrap this up soon. I do have one more comment, and then I had a question to Tina. We've been having a lot of conversations. My comment was, we did see, just for everybody's information, that the University of Minnesota chapter of the AAUP, American Association of University Professors, did just endorse this tenure policy change also based on our consultation so far. But again, there could be additional changes or consultation. This is not final as our recommendation until the faculty Senate vote, which then again, the regents make the final decision. And I did want, just briefly, I think it might help Tina. Can you explain in the new ones? I understand the old, and I think I understand the new. There's both violations that meet the Title IX definition of sexual harassment, and there's those that don't, but still meet the University of Minnesota policy of sexual harassment. Are those the same, or there's a slightly different, still informal process in the non-Title IX allegations?
Sure. The Title IX regulations are kind of confusing because they only apply to certain types of sexual misconduct. They define sexual misconduct fairly narrowly. And historically, our institution has chosen to define sexual misconduct more broadly, to prohibit more misconduct than is covered by the regulations. So as an example, the Title IX regulations don't apply to any conduct that happens outside the country. So, they don't apply to sexual assault that happens on study abroad or at an international research facility or international, academic conference, whereas our policy would. I think through consultation, the consensus has been that we would like, as an institution, to continue prohibiting the broader scope of sexual misconduct that we have prohibited, even though it is not required by the regulations. So what that means is that the regulatory requirements only apply to some of the sexual misconduct we prohibit. We've decided that it doesn't make sense to treat them differently and to provide different processes for Title IX and non-Title IX sexual misconduct, except in a few instances. One of them is dealing with how evidence is admitted. The Title IX regulations are very restrictive about the types of evidence that can be considered in Title IX sexual misconduct cases. And we're worried about that. And so we don't want to apply that regulation where we don't have to in non-Title IX cases. So that's one difference. And the second difference is that the Title IX regulations don't allow us to reach any kind of informal resolution in cases where a student brings a complaint against an employee. We're also worried about that because we are worried that students may be deterred from bringing complaints about employees if they know that the case has to go to a hearing in every situation. So we have decided that we don't want to apply that regulation where we don't have to in the non-Title IX cases. So it's the regulations create kind of this technical complexity, but I think the bottom line is that our institution is going to continue to prohibit the broad sexual misconduct, or at least that's our proposal that we have in the past.
Thank you, Tina. Chris, I see we have one hand up. Is there anyone ahead of Carol?
I just see Carol and then Greta Friedman Sanchez. Okay,
I'll call on Carol first, then Carol.
Thank you. So I wanted to mention this as a comment rather than a question. I was part of a number of the consultation groups as the policy changes were being considered and the tenure code proposal was being considered. And we heard from the beginning the importance, the difficulty of importing the procedures for hearings of this kind into the tenure code. And I believed that to be the case, but I have to say now, having read through the 30+ pages of detailed description of how the hearing process will work, it is very clear to me that that is absolutely right, and that it would be the wrong thing to do to try to keep hold of these kinds of considerations and hearings under the tenure code. And then in addition to that, it makes a great deal of sense to have a centralized process where there can be trained individuals who commit themselves to the time and effort that's required. And I also just wanted to add that it's a really clear, well thought out description of the process that will be engaged in for these hearings and for the appeals, and making it even more acceptable to turn over the process, to take them, to carve them out of not only the tenure code, but the other codes as well, so that we can have a reasonable, clear, well-designed, well-regulated process to make these very important decisions.
Thank you, Carol. I'll call on Greta next, please. Whenever you're ready, Greta.
Thank you for taking my question. I understand in the current system, the hearing officer is also the officer that does the investigation and is the officer that makes a decision. Is that the same case for the new system that we are proposing? Okay, so so I'm not a lawyer. You, Carol and Tina, of course, you are lawyers, but it seems to me that there are some issues where the investigating officer is the same officer that is making the decisions. Shouldn't those be kept separate?
So that is a good point, and that is exactly the position that the federal government has taken in the regulations, that the investigator cannot be the person who makes the decision about whether someone violated the sexual misconduct policy. So that is why we propose forming this hearing committee that will consist of panelists who will be the decision makers. They will make the decision on whether the university's sexual misconduct policy was violated.
So just a follow-up question. So it will be the panel that will ask the hearing officer then for more collection of evidence?
So the way it will work is that the campus Title IX office, like EOAA on the Twin Cities and Duluth campus, will investigate, and we will produce an investigative report that contains all the facts that we found and some analysis and potentially recommendations. Then there will be a hearing held, and this will be a de novo hearing. They will consider all of the evidence fresh, and the investigative report will be one piece of evidence that they can consider, but they can also consider additional evidence and hear witnesses and hear from the parties and ask questions of the parties. And then that hearing panel will make the university decision on whether the policy was violated.
Thank you. Next question.
Next, we have David Andow.
Hello. My internet has been cutting out, so I'm not sure you're going to get all of this. My concern is that sexual harassment issues are often related to power differentials, and putting a live hearing in place sort of creates another barrier towards that. Has the committee considered how to mitigate some of those barriers?
Yeah, that is a really good question, and I think I share those same concerns. We know that sexual misconduct is very often not reported. We know that the reporting rates are particularly low when there is such a power differential. For example, when a student is experiencing sexual misconduct from a faculty member, or a supervisee is experiencing sexual misconduct from a supervisor. And we do have concerns that adding kind of this live hearing requirement in which advisors will have the opportunity to cross-examine the parties could feel very intimidating to particularly people who are in a lower position of relative power. We are thinking about ways to try to mitigate that power differential. One of them is to have a professional hearing officer who can be empowered and experienced and skilled at controlling the hearing and making sure that it is civil and that the questions aren't asked in an overly aggressive way and that the parties have have breaks when they need them. Another potential way to just ensure that our hearing process is as humane as possible to both parties is to provide both parties with advisors that can guide them through the process, which is a piece that we're working on as well. And then I think one additional piece that is permitted under the regulations is that sometimes it can be very hard for the party, especially to be in the room together during the hearing. And that doesn't have to happen. We're allowed to have the parties appear virtually, through some kind of recording, a Zoom or something like that, so that they can be in their own space and don't have to be face to face with the other party. So those are some ideas, but I would say that this is a huge topic of conversation among our team and also kind of among my colleagues at other universities, is how do we make sure that we still create a system that is accessible to people who've been harmed and that doesn't feel too daunting or intimidating, while still making sure that we have all the procedural fairness protections to get to the accurate answer, which is extraordinarily important.
As much as you can do would be very helpful, I think.
Right, thank you. Chris, who's next?
Our next question comes from Adam Sikla.
Hi, Adam, please go ahead.
Hello. Currently, the student sexual misconduct subcommittee runs the hearings for student cases. So if this update is the SSMS purview being expanded to all types of cases, or is it like a de novo committees being formed and SSMS will be dissolved?
What the revised policy would anticipate that the SSMS would be dissolved and that a new committee would be formed. My view is that the panelists that currently serve on the SSMS are kind of a ready-made pool of, devoted, experienced, skilled, and trained folks who I hope will become part of the new hearing committee. But the new hearing committee will also be broader. It will include not only panelists from the Twin Cities, but also from the other campuses. And the panelists will serve not only in student cases, but also in cases with employee respondents.
Okay, thank you.
The next question is from Jerry Cohen.
Hi, Jerry, please go ahead.
Unmute. So I'm Jerry Cohen, CFAN's faculty member of the Senate Judicial Committee. And as a scientist, I like to form hypotheses. And so I just have one concern about this, and I actually support this, but when I look at it, I can see in some future generation a provost who wanted to remove tenure from a faculty member would simply have to find a member of staff or a friendly member of the community to bring charges against a professor, and that provost then would have 2 votes out of the 3 on the panel. And so it's a backdoor to tenure in essence, because we now have an administrative system by which tenure can be removed in a rather arbitrary manner. And if it's arbitrary, you could appeal, and who appeal to? Oh, the provost. The same would go on the coordinate campuses. So I just want to bring that up because this is the kind of concern that we at least need to think about. And I think, a lot of this has been foisted upon us by a federal that doesn't really believe in Title IX, but we don't want to lose tenure as a rather sacred part of being a faculty member in the process of trying to come to grips with this. So some thought about that, at least I want to put forward. All right, thank you.
Thanks, Jerry, for your comments. And we had discussions about this, that it could have, allegation of sexual misconduct could affect tenure potentially if it affects teaching, research, or service, but it's kind of that way already, and we don't believe this will change it tremendously. But we did ask Rebecca Ropers to be on this as a guest. Rebecca, do you have any additional thoughts?
Yeah, hi Ned. I would just echo what you just said, that when there is behavior that affects the ability of a faculty member, the performance of a faculty member in those key areas of research, teaching, and service, that they can be considered already. For example, if a faculty member is harassing his or her students,
then that is something that that person's colleagues can take into consideration when they're evaluating the quality of that person's teaching. So to some extent, that is something that we are already considering.
But that would, those cases, Rebecca, then it would come to us on the Senate Judicial Committee for review. So that this would be different because it would be outside. The review would no longer be through the Senate Judicial Committee. It would be a review to the Provost's office directly. And so that makes it a different issue relative to tenure than our current.
That's a good point, Jerry. We had discussions and there's no final decisions, and it might be complicated of could there be, instead of just to the provost, a faculty review committee for faculty, a staff review committee for staff, to the HR vice president, and a student review committee for students if it came to that as an option. And I think it might be complicated to try to have that right away for August 14th, but I believe, and Tina, correct me if I'm wrong, we could change the administrative policy to do that if there was a strong consensus behind an additional part of the appeal process. Is that possible, Tina?
I think it is possible. I would want to look some more. There's pretty strict privacy rules in the new regulations, so we would need to assess those just to ensure that they would allow sharing information about a case with a broader group of people. I'll just make one additional comment, which is, I mean, Jerry, you are right. The recommendations for discipline will be made by a panel under the Sexual Misconduct Hearing Committee and not through the SJC, although that panel will likely have faculty members if there's faculty involved on it. But I would say that under the new regulations and under the system we're proposing, undoubtedly it is providing additional protections for respondents. I would say the rules of evidence that need to be applied are favorable to respondents in these cases. They make it more difficult for evidence to be admitted. I would also say that it's a significant change. You know, currently right now, if there's a sexual misconduct allegation against a faculty member, the campus Title IX office would determine whether the policy was violated or not. And there is that's a final decision and there's no review of that decision. I think it is actually more fair that there will now be a review of that decision, that, you know, instead of EOAA making that decision, it will be a panel of peers that makes the decision of whether the policy was violated, and there will also be an appeal of that. So just, I understand you know, your real concerns, Jerry. I also think that there are areas where this is providing kind of significant more protection and more layers of review in these cases.
Thank you. Chris, who's next?
Next, we have Tabitha Greer-Reed.
Great. Hi, Tabitha. Please go ahead.
Good afternoon. Hi. I think a similar conversation arose at our Senate Consultative Committee meeting on Thursday, where, let me make sure I get this right, because it is a complicated process, where I think the panel would make a recommendation which would go to the dean. Is that right? For faculty, in the case of faculty. And then the dean has the, I guess, responsibility of implementing appropriate sanctions, whatever they may be, or the recommendations. And one of the ways that this departed from current practices is that there wasn't an additional level of kind of peer consultation or peer review at that level with the dean. And so they maybe one thing to continue to think about is whether there might need to be some panel that would be appropriate for faculty, say, once the dean is dealing with the recommendations that the dean consults at some level. And then of course, if we're trying to make everything flat, then as Ned mentioned, something for staff, something for students, but with attention to privacy. I think that's worth continuing to think about.
Tabitha, Chris, who's next?
Our next commenter is Matthew Croft.
Hi, Matthew, please go ahead.
Hello. Yes, my name is Matthew Croft. I'm the student senator, one of them from CSE. And I guess to be very blunt, if I could ask the presenters, is the notion that these rule changes are expressly because of the Title IX revision, and if if the Title IX, was revised again, perhaps to resemble more what it is currently before these changes, that we would simply revert to, or there'd be a sense that we would revert to kind of how we're doing it now. Kind of in other words, like, are we essentially just doing this because we have to, and we are only going to implement these changes as far as we have to?
I would say we've had discussions of that. Thanks for the comment. And even the faculty consultative committee in our retreat last August was talking a little bit more about faculty accountability, and we had been pressing for a little more openness on what typically happens in the current EOAA, things with not privacy, not specific ones, but in general. And I think there is a consensus, parts of this are good, that the faculty will be treated more similarly. And so it's not an automatic, if they go away, it would go back. There could be changes to the administrative policy if future administrations make different rules. But I have heard from quite a number of faculty that they do believe for sexual harassment, faculty should have similar accountability to staff and students. So to me, no, not automatically back. And it would take if you were going to take it back out of the tenure policy, the regents would have to vote on that. Again, a big deal. So that doesn't happen simply. And we meant to lead it as the carve out. And then if there were changes, hopefully just change the administrative policies would be the goal.
So basically, you're kind of you're looking at this as an opportunity to kind of visit these regs, but it's some of it is a willing change, and that, like, especially when the comment about the evidentiary standards, about how we would not be using these standards were they not required of us. But so you're saying it's kind of a mixed bag. Some we're kind of unhappy about, and some we do think are good and necessary.
Yeah, I think just generally, I'm also on the steering committee of PIPS and the President's Initiative to Prevent Sexual Misconduct. So partially with that hat on, we are worried about complainants not coming forward as easily, and Tina's trying to do all she can to make sure that's fine. But it does give some more consistent procedures and consistent accountability to the respondents. And I think from what I've heard at PIPS, and there's support for that part of it. So it is a little bit of a mixed bag there, and that we had been in faculty governance talking about more faculty accountability, and not to, whether real or perceived, that faculty could get away with something that others couldn't, and that should not happen. And that's part of the good part, is that there will be more accountability and openness, that it's similar with faculty.
Thank you.
Our next question is coming from Scott Petty.
Hi, my name is Scott Petty. I'm a student senator from CFANS. I just wanted to add a fact. So last year I drafted and COGS proposed a referendum for the all campus elections on the Twin Cities campus. I was the one who drafted our language. And while not touching any of the substance of this discussion, the question that we proposed to students was, should there be a single standard for tenured faculty and everybody else? Basically kind of asking students to express disapproval for there being two different standards in sexual harassment cases on campus. And so in the spring semester of 2019, this vote was held, and 96.3% of students voted in favor of our referendum, which, however it settled, substantively, whichever way this settles, I think it's just worth noting that, at least from students, students overwhelmingly asked for some action in this direction last year, for there not to be two separate standards, one for tenured faculty and one for everyone else in sexual harassment cases. And I just felt that was worthy of being added to kind of the record of the discussion. Thank you so much.
Yeah, I'll just say briefly that I think at our institution, there's been a history in sexual misconduct cases of students really pushing us forward. And I appreciate COG's resolution on that. And we'll just also note that there was another resolution from COGS that really asked for student consultation on discipline in cases where students are a party and there's an employee as the other party, as the respondent, and that really laid the groundwork, I think, for our proposal now, which where a student who's a complainant can choose another student to be on the hearing panel when they make a complaint against a faculty or staff member. So just thank you to kind of for the thoughtful feedback that COGS has given us over the past couple of years, because I think it has moved us forward.
And from the faculty perspective, thank you too, Scott. That's a good point for everybody to know. And then it sounds like there's consensus coming around. The vast majority of people believe that's a good thing, that the faculty will have the same accountability in sexual harassment under this as everybody.
Chris.
Our next commenter is Ryan Elliott.
Hi, Ryan, please go ahead.
Hi there, thank you. So this is Ryan Elliott, faculty senator from aerospace engineering. I was just wondering if we could hear some explanation of how changes to the university sexual harassment policy would be taken in the future, and how that would compare to changes that are possible now under the tenure code if we make this change. So would faculty have the same sorts of input and authority under future changes if we make this change to the faculty tenure code?
I'm not the full expert on this. I'll start, and then Ned or Rebecca or anyone else can jump in. But so the administrative policy would have different consultation requirements in order to be revised. There are requirements to change the administrative policy on sexual misconduct to meet with and consult with a number of governance groups, including the faculty consultative committee. I would say that the Board of Regents, even though the sexual misconduct policy there's a board and administrative policy. In the past, the Board of Regents has wanted to approve both of them together. So there has been an additional layer of review with the sexual misconduct administrative policy. But I think, just to answer simply, there is a different process to amend the tenure code than there is to amend the administrative procedure. And I think a big difference is that there is, to amend the tenure code, an advisory vote by the faculty senate is required, whereas for the administrative policy, faculty consultation is required, but not necessarily that advisory vote to the regents.
Yeah, I would concur with that the faculty would have the ability to go forward with the proposal again through the same process to the regents if the faculty felt there, with a future change, it was important to modify the tenure policy for this with the same process. Otherwise, if it's all changed within the administrative policy, which would be the hope, that would be the simpler if everybody thought it was a good thing with a future change, or if the courts intervene before August 14th, to still have a similar process across all groups, but the usual influence on administrative policies through the governance procedures, or the faculty does have the ability to look at the tenure policy again, though ultimately all approved by the Board of Regents in either case.
Are there any additional questions or comments?
I do not see any more hands raised at this time.
Okay, if questions or comments occur to you, you can email them and we can continue the conversation that way as a discussion item. Obviously, this is an ongoing conversation. So thank you very much to Tina and Ned and everyone else who chimed in, everyone who's been involved in this work. Thank you in advance for the work that still remains to be done. So, okay. Now we're going to turn to a discussion of a proposal for the first time in what I understand is a very long time to amend the bylaws in order to add a new committee, in this case, a campus safety committee as a new standing committee of the Senate. Before students can really thrive, it's very important that they feel safe, and that feeling of safety needs to be in all of the dimensions and sense of that word. And we know that the tragic murder of George Floyd has sparked significant conversations and calls for action across our community in different ways and from different voices, but in particular in support of our BIPOC faculty, staff, and students and their specific and honored and dignified needs. Shared governance, as you know, and of course for this body, almost goes without saying, has the cornerstone and important role in these conversations as a university. So today we have a discussion of a specific proposal to create a campus safety committee as a standing committee of the University Senate. It's important to note that there are additional proposals listed in the agenda under item 3. Some of these proposals are are under review with Student Senate, who took one look without quorum that may take another look again. There are also demands from different groups that have come either directly to me or to me and the Board of Regents that relate to these issues that have not come through as formal Senate proposals, but are obviously directly relevant to the issue that we'll be discussing. I see my role today as active listening and learning about what the shared governance voice of our community is saying, wants, and needs, while also thinking about the bigger strategy at the university and within our community for how we confront systemic racism and dismantle it, ensure that everyone feels safe in every sense of that word. I should mention that at next week's Board of Regents retreat, I'll be discussing this issue with them and thinking about our next steps. Those next steps are likely to include, given the fact that health and safety is actually a Board of Regents area of oversight that has been delegated to the president, but is still inherently within their authority, how we receive either outside review or third-party advice of how we work towards a full and robust safe campus and how we define that for our campus in every way, including looking at UMPD, what that means for them in terms of their size, their budget, how they present, how they're trained, and some of the other issues that have been raised. I don't say this because of anything other than the fact that the question has been called legitimately across the community, across the country, and arguably around the world, and we should be a part of any answer to that question. I'm also open to what might need to come next, including decreasing the footprint of deadly weapons, thinking about other ways in which we can all work together around safety and the different nuances of that have come forward by virtue of the different voices being expressed. And then presenting that and discussing that with the Board of Regents as appropriate. I will also be talking with the Board of Regents to advance the EAD committee resolution that identified the formation of a task force of students, faculty, and staff to review current institutional responses to address the issue of systemic racism, security and safety, policing, among other topics. This task force is identified in the resolution as representative, with members chosen in consultation with the Senate committee leadership and other advocacy groups. So after the board retreat, my intention would be to do as we have been doing as we've been working through these issues, is to come back to you with an update for consultation and feedback. This is a strategy that we intend to have as a co-created strategy for our entire community, representing that we don't all agree on this issue, but that we all have legitimate voice and that we intend to hear that voice and work within the range of voices to find a solution. So this has some procedure associated with it. Bylaw amendments are a very serious matter for any deliberative body, and we're no exception. So there are special procedures for considering and voting on proposed bylaw amendments that I think are appropriate for us to review before we begin our discussion. First, the University Senate Constitution requires that any proposed bylaw amendments be circulated to all senators at least 10 days before any meeting where the proposed amendments are considered. This is to make sure that senators have sufficient time to consider and reflect on a proposed amendment before it is considered by the body. In this case, the language of the proposed amendment was circulated to all senators 10 days ago on June 19. It is also part of the docket materials for today's meeting. Second, because of the constitutional requirement of at least 10 days notice, it is not possible to take amendments from the floor that make substantive changes to a proposed bylaw amendment. This is because the body would not have had the required 10 days to consider any such amendments. So we'll have a discussion of the proposed bylaw amendment for the next 30 minutes or so. And after that discussion is concluded, I'll ask if any senator wants to make a motion to vote on the proposed amendment. This would essentially then become an up or down vote of the proposed circulated amendment as issued on June 19th. And pursuant to Article 11 of our Constitution, if the proposed amendment is voted on today, it must be approved by at least 135 senators to pass. That is a majority of the voting members of the University Senate. If the proposed amendment is voted on today and a majority of the senators present and voting vote to approve it, but that number is less than 135, the proposed amendment will be carried over for a second vote at the next regular meeting of the University Senate. If the proposed amendment is voted on today and is not supported by a majority of senators present and voting, it will fail. If the proposed amendment is not voted on today at all, it will be referred to the Senate Consultative Committee for additional consultation with affected constituencies, with an eye towards presenting a revised proposed bylaw amendment that incorporates this additional feedback at a special meeting later this summer. Now, given that I see my role today as listening and learning, and given the nature of the amendment on the table, I'm going to cede the chair to Vice Chair Carol Chomsky, who will facilitate this portion of our agenda. So with that, I'll turn it over to Carol. Thank you.
Thank you, President Gable. I will now call on Professor Amy Pittenger to present this item.
Thank you. So the next item on the agenda is a consideration of the formation of a Senate committee focused on campus safety and the bylaw change necessary to form that committee. As you just heard President Gable explain, at the end of the discussion, any senator may call for a motion to vote to approve the amendment as written. I want to emphasize that we cannot vote on a revised version today. The student authors of the proposal are here and are ready to respond to senator questions. I also want to comment on the bigger issue of systemic racism and the many ways a historical and complex problem such as this must be addressed, because we have received concerns that the Campus Safety Committee was being proposed as the only action. The Campus Safety Committee is just one part of what must be a multifaceted approach to impart meaningful change. I want to emphasize that this was also an important part of the SCC discussion last week. And I know that the student authors of this proposal agree that a Campus Safety Committee alone is not a sufficient response to address such a complex issue. If this amendment is adopted, it must be the first of many actions. Today is really focused on process, but we know that process is not enough. Substantive goals are necessary to develop and execute a good process, and the Senate is committed to leading a conversation on some substantive goals with the plan for a Senate resolution later this summer. Student advocacy groups brought forth a number of proposals to address institutional racism at the university in the wake of the murder of George Floyd. While this discussion will focus on the proposed Campus Safety Committee today, the other proposals are, at least at this time, not directly under the purview of the University Senate, although the SCC has provided them for information in your docket. And while we are not specifically acting today on the other student proposals included for information in the docket, soon to be FCC Chair Phil Bowman and I commit today on behalf of the FCC and the SCC to bring forward this summer for Senate consideration commitments that will guide our actions as we confront institutional racism and the many ways it negatively affects our community. Once these principles and commitments are established, we will move towards concrete policy changes to advance our university towards a stance of active and persistent anti-racism. The murder of George Floyd was not the beginning of our efforts to address systemic racism. Initiatives to disarm UMPD, rename our buildings, and others started before this most recent tragic event. One of the suggestions that came forward from the fall forum on institutional history was that we create a devoted space for our actions related to institutional history, a landing page devoted to our commitments to address this complex problem in real ways with meaningful action. I propose that these commitments that I just commented on would go in this location and be a visible reminder of what we're trying to accomplish as we take action. Senator Isaiah Ogren has already begun the work on the guiding commitments and has agreed to lead the continued effort that will be brought to the Senate later this summer. This matter will continue to be treated with urgency. Broad consultation will take place for these principles with the voices of students and Black, Indigenous, people of color foregrounded. From these concrete principles, it will be much easier to move forward on concrete policy changes, which we are committed to doing. So again, I just want to assure you once more that the SEC sees that the possible formation of a campus safety committee as just one part of what must and will be a multifaceted approach to impart meaningful change. I ask senators to focus today the discussion on the following proposed campus safety committee. And with that, I'll turn it back over to Vice Chair Carol Chomsky.
Thank you. I believe Matea, Iman, and Scott are prepared to present for a few moments on the Campus Safety Committee proposal. I'm not sure who's speaking first, but I would call on you to do that.
Thank you. I can go ahead and get started. And I would also want to add Josh Lesser, who is the Vice President at PSG, into the speaking role. Thank you, everybody, for.
Oh, you muted again. Iman, you muted?
Okay, good. Is that working now?
Yes.
Sorry, I'm at like a public courthouse right now, so the Wi-Fi is shady. So everybody's probably had a chance to look at the material, but I just wanted to at least provide a little bit of background as to why PSG and COGS are putting this proposal first. And Matea, feel free to hop in if I missed something. In response to the murder of George Floyd, PSG and COGS created a task force of professional and graduate students in conjunction with faculty, staff, and community leaders to come up with, to research and come up with actionable practical steps that the university and individual schools could take to address both policing issues and issues of institutional racism, both within the larger university and individual schools. And so these students have been working tirelessly for the past month to put together a variety of recommendations that we are hoping to consult with on the administration throughout the summer, with the goal of really putting forth solutions that are practical, things that the university can do and are backed by research, and bringing in the people who are most affected by these decisions. And so one of the recommendations from our policing task force was the creation of the Senate committee. This is particularly important because we realized just in this process that there is really no central avenue for us to really cut through a lot of the red tape. And I can't speak on behalf of everyone else, but I imagine that other student groups and student bodies that are putting forth their proposals might feel the same way. And we really wanted to have some action that the university can take right now to create kind of long-standing change and provide an avenue for students and faculty and really anybody to put forth their concerns, to learn from each other, and have a single kind of committee where people can go to. We wanted to create this committee also because a Senate committee mandates a university response, which is particularly important, at least for PSG and COGS, because that's the key thing. We need the university to respond to things when they arise. And so having a place where students can go to present these proposals with the confidence of knowing that they will get some response is really, really important. And in addition, we want to emphasize the broad scope of this committee. So this committee is not just, limited to, UMPD. It embodies all campus security and safety concerns, and it provides an avenue for different issues that may come up later, long after Matea and I and everybody's gone, and really provides an area for students to be able to come with any concerns so that, hopefully this campus becomes a safer place overall. And finally, to kind of touch on the previous point, this is supposed to be a very broad path to change. All the other proposals, including the ones of our own task force and the other ones before the Senate, we really view this committee as complementary to those, if not providing an avenue for those proposals to later go through. And with that, Mattia, did you have anything else you wanted to add?
Yeah, and I guess like one important point that I want to emphasize is that this is not just a university, like a Twin Cities committee. This is going to be a system-wide committee because UMPD operates on all systems at the University of Minnesota.
Thank you. Are the other Scott or Josh, I think you said also wanted to speak at the beginning, or should we open it for comments and questions?
I'm fine with moving on to questions.
Oh, go ahead.
So I'm fine with moving on to questions and comments.
All right. Chris, Josh, did you have something? Sorry, before we move on.
No, I just said as am I.
Okay, thank you. Chris, do we have people wanting to speak or ask questions?
I do not have a raised hand at this time.
I can't figure out how to raise my hand.
All right, let me, before I call on you, I should just say, especially because of the Zoom environment, it would be helpful. Please, if each speaker can say where you are a senator from when you speak, say your name and where you're a senator from. So Leanne, go ahead.
Sorry, I figured it out. I'm Leanne Shore. I'm from the College Valley Health. One of the things that I don't understand is that when this was sent to us, I asked how I could comment. I sent that comment back to whoever was hosting the document, and I never received a response. So I had a question about how we were creating a committee in which the voting arrangement was not equal. And I had concerns about that. I don't believe we should create a committee to start that already has unequal rights in voting. There were more members on one side than another side. And that seemed to be a strange arrangement to start a committee with that kind of situation. And so that question is something I still have and was not addressed at all.
Can Jeanette Poole load slide 5 from our slide deck?
Yep, I'm getting that loaded.
So Scott, will you be answering or?
So we made this table to summarize the representative nature, to describe to translate our proposed roster into representation.
Okay, thanks.
Mattia and Aman can respond.
Yeah, so this table looks at committee composition. And so what we did is we looked at OIR's numbers and looked at sort of the breakdown between students and then between employee classes, and then the breakdown of students on the systems campuses as well. And so our proposed roster is going to be the first column. And so we have 6 faculty, 2 P&A, civil service, students, system people, etc. And then we looked at the total population that those people are then representing. And And then we further broke it down and then looked at the population that the representative on the committee would represent her reps. So for example, one faculty member on this committee would represent 792 faculty, opposed to, you know, one graduate student on the Twin Cities campus who would represent 4,000 people. So this, I guess I'm sort of confused about in what way you feel like, was it faculty or, sorry?
I didn't have this information. This wasn't what I received. I didn't receive anything like this. I never saw this.
Okay, so, I mean, I would say that, you know, that these faculty members are very well represented in our group.
Let me add one point of information and then go on to the next question or comment. If the question is about representation, the choice of how many from each category, Senate committees as a rule have varying numbers of representatives, and so you could compare this to the representatives that are on each of the other committees. It is typically not equal across the board, just by point of information to compare with the others. Chris, who is next?
Next comments is from Greta Friedman Sanchez.
Greta, go ahead.
Thank you. I have both a comment and a question. So me and the Humphrey really appreciate the focus and the framing of the committee on safety. We consider at the Humphrey School, and this has been echoed by other bodies at the university, that Black voices need to center the effort of the committee. And so the question that I have, and this is coming from the Humphrey School, is what has happened in the discussions of how the proposal, the aims of the committee, the alignment of that purpose, its scope, the authority, the accountability, answerability, and the last question on member composition, how are those going to be coordinated and aligned with each other? And so this is one point where usually committees fall apart and where the main purpose of a committee is not able to really carry forward. So has this been thought about? And if not, a member of the Humphrey School, Kathy Quick, has been working on these issues, and she would be very happy to help with this.
So I can take that. A member of our task force has been to talk to Kathy Quick at some length. I was not present. I don't know the full scope of the conversation, but JT from our task force did in fact go and talk to Kathy Quick and brought us back some comments from her.
I would also add that we received the task force recommendations that Kathy Quick had come up with regard to the Falcon Heights shooting, and we have reviewed those as well and incorporated information from that into our task force work. And also Kathy Quick has been in consultation with the policing group regarding ongoing action. Scott, I'll turn it back over to you. Sorry.
My only comment was, yes, we have been to speak with Kathy Quick. None of the four of us went to speak with her, but a member of our task force named JT did go and spend about an hour with her and brought back comments, and she sent us a document from the Falcon Heights shooting that has informed much of our discussion and our proposals. I don't know. Oh, sorry.
Well, to finish your thought, sorry.
I can't point to what elements we've mapped from our conversations with her into this specific proposal, because our little kind of joint task force has generated like a whole series of proposals, of which this is just number one. I don't know, I can't point to specific things that came from conversations with Kathy Quick that have been mapped into this particular proposal. I can point to things that I know went into other proposals from our discussions with Professor Quick.
I think that
I'm going to, as chair, because I want to make sure that in the time that we have time to receive comments from all those who want to make comments and ask questions, that rather than, typically our process is not a back and forth answering individual questions. We've done that on some of these complicated matters, and even then sometimes wait until later. So I will give you one more moment, Greta, but let me just say that what I would propose to do after this is call on those who have questions or comments and ask the presenters who might have answers to just answer a number of them at once. And so we can get as many comments and questions as possible, and then leave you time to answer all the questions. But Greta, I'll give you one last follow-up.
Thank you. So the most important point is actually not on specific policing recommendations. The most important question that we have from the Humphrey School is that the design of the committee is of utmost importance, and that the composition, the charge, that needs to be, and the purpose need to be aligned, because this is a way that we will make big changes. We have had other types of committees making little incremental changes, and that isn't working. So the most important point is aligning the design of the committee and the different components of it so that it is effective. Thank you.
All right. Thank you, Greta. Chris, who's
Thank
next?
you, Greta.
Next on my list, I accidentally lowered her hand, is Erin Heath.
Go ahead, Erin.
There we go. Hi, thank you for the chance to speak. Just a couple things. Well, first, we certainly appreciate that this committee is being formed. We saw that the letter that we sent to SCC has been shared more broadly. And so my intent really is to summarize some of the things that we mentioned. The most important being that we are supportive of a committee being created, that our concern really had to do first with the consultative process that occurred, as well as how members are selected and the proportion of members which are going to be on this committee. First, since we're concerned that the composition of the committee, given the limited governance, may not actually be as inclusive as it should be for such an important topic. Secondly, in terms of the membership, staff makeup, as you saw on that previous chart, a pretty substantial portion on campus and of course system-wide. And so we are advocating to have a more proportionate representation on this committee, realizing, of course, that it's really hard to put together a committee of this importance with so many people who are involved. Everybody wants to have a say. And yet it seems that staff, P&A and civil service in particular have been historically underrepresented. Realizing respectfully that that is what is currently in governance for practice. Yet we think this would be certainly a good time to advocate for a change, that we do have more representative proportions on the committee. And we would also ask that that the membership selection be more closely tied to governance, the staff governance in itself, as compared to committee on committees. So we would be requesting a more direct involvement in how members are selected. Thanks.
Is it proper for me to respond, Carol? You're muted.
Oh, you're on mute.
Thank you. I should know better. No, I'm asking that we get the comments and questions, the hands that are currently raised at least, okay. and then there's time to discuss as in response to some of the questions and concerns. Thank you, Scott. Chris, who's next?
Next, I have Noel Noonan.
Go ahead, Noel.
Thank you. I'm giving my time to uplift student voices directly in this process. So with that, I yield my time to Fanta Diallo and Jayla Lehman as representatives of SDS.
Thank you so much, Noelle. So as students with SDS and UMN Climate Strike leading the movement for police accountability on our campus, we encourage members of the Senate to vote no for the Campus Safety Committee and instead support the Campus Civilian Police Accountability Council. We are frankly appalled at how this body has silence undergraduate student voices and have attempted to water down the demands of our movements. As university and student senate members, you are supposed to represent us. You are supposed to be accountable to us, yet you choose to make backroom deals that leave us out of this process and prevent us from making real change happen the way we need it. What experiences do you have that allow you to make these decisions for minority communities? We've said it time and time again, but Black people are experts at their pain, which makes them experts in the solution. Not listening to that only allows you to stay comfortable. You can't say you're committed to dismantling institutionalized racism, then lack any ensured representation of BIPOC on your committee. We don't want another powerless oversight committee or community or board. We want the university to do what we need.
We want a Campus Civilian Accountability Council that puts the power to oversee and control UMPD into the hands of students, workers, and community members. We want the power to determine the UMPD budget, to hire and fire cops, and to review misconduct and take disciplinary action. We want this power and we want nothing less. Your proposal accomplishes none of our demands. Any proposals that offer less than our demands are nothing but detrimental to our movement. To President Gable, we don't want an outside third-party review of UMPD. We want a student and community review of UMPD. They police us, therefore these decisions should be made by us. We are on the front lines, hosting protests and actions every week. We are mobilizing hundreds of students. Listen to our voices. Listen to Black voices. Do the right thing and give us a platform to make change at this university. Vote no for the Campus Safety Committee and support Campus CPAC.
Thank you for both your comments. Who's next, Chris?
Next, I have Sherry Breen.
Go ahead, Sherry. Sherry, are you there? Let's maybe go on and come back. She may have stepped away.
Let me see if I can pull her up. Here we go.
Ah, okay.
Sherry, we're not reading you. I know it says you're unmuted, but we're not hearing you.
Maybe because of this ventilator.
Let's come back, and hopefully Sherry we'll put her back in the queue as soon as possible to avoid taking time for technical issues. Who's next?
Next, I have Tabitha Greer-Reed.
Thank you. Go ahead, Tabitha.
Good afternoon. I am a senator from College of Education and Human Development on the FCC. I had a couple of questions. I wondered what the mission statement, or if you had a mission for your committee, and then how it overlapped with the Public Safety and Advisory Group, which was critiqued in the community, I don't know if I'm getting the name right, but the CAPD, I think, board as being rather kind of toothless. And so what is the relationship of this committee you're proposing with that one? Would it replace it? Is it overlapping? And then I guess related to the other previous comments, where I think I am inclined to agree that in some ways this committee seems small in reaction to the large social tensions and need for structural change that we need, how you have centered Black voices in your composition of this committee and you're thinking about how to address these issues.
Thank you. Next in the queue, Chris.
Next, I have Isaiah Obrin.
Go ahead, Isaiah.
Thanks. I would just say, with respect to the committee's composition, there are a great many committees where students are outvoted by ratios of 2, 3, and maybe even 4 to 1. Indeed, in the Senate as a whole, there are over 3 faculty senators for every student senator. I think that there's room for tinkering around the edges with the relative representation of P&A and civil service relative to faculty in particular. However, it is important that to remember and note that students are the folks who interact with UMPD officers the most, and students should, because of that, students should have a disproportionate seat and space on this committee. I would also note that one of the things that we're confronting right now is what it is possible to do at a given moment, especially because other actions such as a stronger police accountability board, which I am very interested in that possibility, are dependent upon Regent's action in a way that this proposal is not, which I think is a worthy point of clarification that needs to remain in our minds of what exactly this body is empowered to do and what exactly this body is able to do given the constraints of time and bandwidth that we're all under. But again, I would just reiterate my support for the appropriateness of disproportionate student seats on this committee, given that it is students both who interact with UMPD the most and who indeed have the most qualms and issues.
30 seconds.
Right. Thank you. I see 2 hands at the moment, and I will ask Chris to name them one at a time, but I think at that point we can take a pause and hear from the Scott and Mattia and Iman, and then go back to hands to make sure everybody has an opportunity. So those 2 that were raised. Chris, who's next?
Well, Sherry Breen has popped up on my screen.
Yeah, I think she's still having audio difficulties on her end. We're working on that. The next one, Ian Pace.
Ian, go ahead.
Hi, thank you so much for recognizing. My name is Ian. I'm the student senator from the School of Public Health. And I would just like to echo some of what Isaiah just said, which is that this committee, while not being able to make some of the changes that we might wish to see on this campus, is something that this body can do unequivocally and without permission from anybody else. And that being able to make that step right now is important. And that also this committee does not in any way preclude other more forceful actions by the university in the future, such as a body that can have recommendations that have to be followed by UMPD on officers hiring, firing, and use of force policies. Thank you.
Thanks. Chris, I think there was perhaps one more.
Yes, James Farnsworth.
Go ahead, James.
Thank you, Vice Chair Chomsky. James Farnsworth, CHG student senator. I just wanted to echo actually what 2 of my past student senator colleagues have said. I think this process has certainly been really difficult for a number of people. I've had lots of concerns and critiques about the process, and I think this can sometimes happen at when everything's moving so fast, especially over the summer. But I just wanted to make 2 points. One, and this is what I said to my student senator colleagues last week, is that it's important to, or could be helpful to some to view this as a yes and, that this is creating an institutional home for future discussions. I, as well as my colleague Senator Ogren has said, I'm very interested in discussions about UMPD Accountability Board, but it's important to remind people that that is really in the hands of the Board of Regents. So, well, again, this process certainly was far from perfect, and there's a lot of valid concerns, many of which a number of students have talked with FCC Chair Pittenger and Vice Chair Bowman about and had good dialogue and discussion about. I think some, folks may see this as kind of this is being done before discussion that a lot of people are interested in having about a UMPD accountability task force, or excuse me, an accountability committee. But just to remember that this is something, again, that's directly on this in the Senate's purview, which I think is, I would assume, is why this is coming up on the agenda first, and that the SCC was
30
used
seconds.
as kind of a discussion place for those other proposals, but that's why this is coming up before us. So just kind of remembering that from the governance standpoint and structure, and why this may be here, and knowing that this isn't the end of the conversation. And as a student, I also expect that this isn't the end of the conversation. I think can be important framing for people.
Thank you. I did say I would take a break at this point and go back to the those who presented the proposal for brief comments. There are, I see 3 more hands, plus possibly Sherry Breen if she's able to get back in. So we still want to have opportunity for everybody, if possible, to comment and ask questions. But I did want to give the 3 of you, 4 of you, a moment to speak to any of the issues that have been raised, if you want to at this point.
Yes. You want to address the first?
So the incoming chair for P&A was speaking about Senate composition, and my response in the moment was going to be like, this is a critique of the entire Senate committee system. And I, at least as the author, as one of the authors of this proposal, I don't necessarily take it as a critique of our proposal so much as a critique of the entire Senate committee structure. As an item for discussion, it seems to me to be an item separate from the discussion of our particular proposal. And my response to Aaron would have been to propose referring that specific item to committee, and that the University Senate may wish to establish a committee of the body to just look systematically at the rosters of all of the chartered committees of the University Senate, and then think and make recommendations back to the University Senate as a whole next year about possibly adjusting rosters across the entire committee structure. If there are people or constituencies that feel that there are kind of systemic issues with committee representation. But we basically went through all of the existing committees and looked at the structures and charges of the various committees that exist while formulating our own. That was my response to the first person. Then Mattia or Aaron, Mattia or Iman might have further comment, or to jump to the next question / comment.
I'm fine with your answer. Thank you, Scott.
Mattia, do you want to take the next one?
Yeah, sure. So I guess sort of what I heard from that is that you're concerned that Black students and students of color's voices weren't being heard, and that we weren't focusing on institutional racism. And I guess I would sort of like to make one point. So I'm Black. I consider myself to be Black, and I am co-leading this task force and was a co-author on this. And my colleague, who is also the co-leader and founder of this task force, is a minority. We have done extensive consultation with both graduate and professional students, in addition to undergraduate students and sort of stakeholders at the university. So I guess I would just sort of like to clear that up, is that we have made this an inclusive process. And also I just also want to sort of like refocus. So we're not focusing on institutional racism. That is not what this committee is supposed to do. That's not what we're asking for it to do. And this instead is focusing on campus safety, so UMPD, and campus security. So I just sort of want to redirect us to that. So we are not addressing institutional racism. We have some proposals that do that, but that's not what's being discussed now. Right now is campus safety, the campus safety proposal. So Aman, do you want to add to that at all?
No, I was I just want to echo what Matthias said and just kind of reiterate that the start of this task force, the point of it from the very beginning was to center Black voices and the Black experience and amplify that. And we have been working very hard, not just for this proposal, but within our task force to remember that and be mindful of that and recognize that, you know, everything that we do, our Black students it has to be centered around their voices and their experiences. And we hope that, you know, while we may have, you know, differences with other orgs about like what's the right way to move forward, I think that this committee in and of itself is an avenue for all types of proposals to come through as opposed to just ours.
You all
Thank you. No, so
the undergraduate students as well.
There are 6 hands raised so far, and we have 15 minutes left on the agenda item as a whole and on the meeting as a whole. So I want to go back to make sure people get to ask questions and make comments before we run out of time. Before we call on the next one,
can we ask
Chris?
Can we ask the Jeanette load a slide, please?
I want to go back and make sure that those who are asking questions and comments can speak and present their points of view at this point. I think, Chris, you have the comment or question from Sherry Breen, is that right?
I do. She emailed me. She was having audio difficulties. This is a few sentences. So she wished to comment, among other concerns, I want to raise the question of system-wide application. Morris, Twin Cities, and Duluth have separate police departments, and they are significantly different. To what extent did the presenters consult with non-Twin City representatives, and how does this proposed amendment address the crucial distinctions among the police departments?
Okay, and then who's next in the queue?
Next in the queue is Scott Creer.
Go ahead, Scott.
Hi, thank you. I just wanted to make a point of clarification. Someone had mentioned that this is a student-centered issue, and we have had several staff members who've been racially profiled by UMPD and security members on campus. And so while I respectfully do admit that this is absolutely also a student issue, it's also a staff issue. And this is why we advocate so hard that representation on this committee should be representative of the community at large and not be disproportionate in any way representing other affluent members that may be reflected in other committees. And I think we have the opportunity to get that right. A no vote today is not a no vote that this can't ever happen. It's a no vote that would allow us to go into a consultative process in which maybe the development of this committee can be done so that it's appropriately representative of the community at large and form a more inclusive committee to ensure that all voices are included in such a committee. Thank you.
Thank you. Next in the queue, Chris.
Next, I have Gunnar Fromm.
Go ahead, Gunnar.
Well, thank you. I am Gunnar Fromm, a UMD Swenson College of Science and Engineering student senator. So this, Sherry kind of beat me to the point, but basically if you divided it in two of this committee, the public safety part and the Department of Health and Safety part, that public safety part is very Twin Cities focused. Only one division within the Department of Public Safety is system-wide. So I, as a system student senator, I don't really see the advantage of having system senators make policy changes on something that is Twin Cities focused in that aspect. So I would maybe suggest that the committee be split into like a subcommittee for the public safety aspect of it, because like Sherry sort of said, UMD has its own police department that's run by our Vice Chancellor of Finance and Operations. So again, just to summarize, I just don't really see an advantage of having 4 system senators direct policy changes on some aspects that are really Twin Cities focused. That's kind of your community, and in a way I feel that Twin Cities senators would be best focused to see change within their own community. Thank you.
Thank you. Next on the queue, Chris.
Next, I have Brett Heischmidt.
Go ahead, Brett.
Yes, thank you, Carol. My name is Brett Heischmidt. I'm a graduate student senator from the College of Science and Engineering. I'd like to speak briefly in support of this and touch on one thing that I think has not been really discussed. And it's the fact that this, Gunnar touched on it a little bit in terms of system campuses, but in terms of the Twin Cities and maybe other system campuses, this discusses much more than just policing, which is obviously a very important issue. But that's one thing that I like about this proposal, in that because it is kind of a broader reach, it can advise on things such as, do we want to replace police with more mental health practitioners or other types of support? And so as you consider this, please consider that as well, in that it has kind of a broader reach than just policing. And that's it. Thank you very much.
Thank you. Next on the queue, Chris.
Next, I have Briggs Topol.
Go ahead, Briggs.
Thank you. I did just have a question in regards to the consultation process. I've heard a couple of people ask as to what was the process for consultation in regards to this proposed committee. And specifically, I'd like to echo the sentiments of the question that was called, that was read out aloud by Chris Kwapik. Just asking about what consultation specifically has occurred with each of the system campuses. If you could just give us that, if you could just answer that, that'd be real awesome.
All right, and I see no further hands raised right at the moment, so it's a good time to get that question answered. And any other comments? I see more hands coming up, but I will, just so you know that there may be some others who want to make comments. So if the three of you or four of you have a response to the last question or other things that were said. Well, let me go ahead.
I can just go ahead and speak briefly on the last one, and Mattia, Josh, and Scott, if you guys want to jump in, feel free. We have, as we mentioned, this task force was created by professional and graduate students who are on not just the Twin Cities campus, and we do recognize that obviously, like Mattia and I being from the Twin Cities, there is a bias towards Twin Cities students and campus security, but we, in having a task force and a diverse task force, we were specifically focused on making sure that we have voices from non-Twin City campuses, because we do recognize that their campus safety landscape looks different, and this proposal was made in consultation from professional and graduate students from all campuses.
I'm not hearing anyone else. There are additional hands on the queue, so we'll try to take very brief, since we're running low on time, very brief additional comments. Who is next, Chris?
I see Michael Minta, who's not been recognized yet today.
All right, go ahead, Michael.
Can you hear me now?
Yes.
Good. All right, thank you. So first of all, I want to thank the students for this very well thought out proposal on the Campus Safety Committee. I've had a chance to look at it, and I also want to thank the other proposals that I saw in the docket. There seem to be really serious proposals that we all should look at. My only concern, and really I think that we need to move forward with some type of oversight function of campus police and how it affects students of color, staff, faculty. But I would like to see more of a presentation on kind of the benefits of this committee. And I don't know if that slide showed it was there where you guys kept showing us different slides. I just want to know how this relates to what our peer Big Ten institutions are doing and how effective are they? You know, just having some more of this information, I think would really be helpful to me and to probably other senators. So, but thank you for this great effort.
Carol, I'd like to, can Jeanette load slide number 2 of our slide deck. And I think I would like to try to answer address Michael's comment.
Okay, and if you can be as brief
I'll
as possible, because we
I'll-
have, just because there are others on the queue, one
I'll
who
try-
hasn't spoken yet. Thank you.
I'll try to be
Thank
brief. So slide number 2. This is the chain. So when we started looking at policing, this is the org chart to get from a patrol officer to up the chain of command. You have to link together 4 different university org charts. So our conversations within COGS in this kind of issue space for Mattia and I began with the AHC security changes in December. The consultation process for that went to the Senate's Finance Committee. So when changes are made to public safety and to security, currently the University Senate is sending those conversations to the Finance Committee, which I'll be serving on next year, which to me seems like a completely inappropriate place for it to be going. And the reason it goes to Finance is because there isn't a dedicated committee that has purview, that the Senate is delegating its kind of advisory and consultative role in public safety to. Jeanette, can you go to the next slide? So why a Senate committee? So Senate committees are permanent. They do not have a fixed life. They're there forever. They're structurally independent. We control them as the Senate. They can do whatever the members of the committee choose to do. They can go down any path of inquiry that they want. A Senate committee has dedicated staff. It isn't dependent on the president's office or the Board of Regents to provide it with staff support. And there's then a required administrative response when such a committee asks questions. Finally, the committee is filled by the Student Committee on Committees and the Senate Committee on Committees, which means that we as the joint governance structure control the membership. I mean, people talk about, though, there's been this committee and that committee every time something pops up. Well, ultimately, the president's office or the provost's office or the Board of Regents are charging those ad hoc committees, and they end up controlling the roster. Can you go to, Jeanette, can you go to slide number, the next slide down?
And Scott, please
So
wrap up, because
we're
running out of time.
I'll stop.
Thank you.
I'll stop here. So one of the proposals coming out of the Equity, Access, and Diversity Committee was for a task force in the president's office. Well, that would have fixed life. What we're proposing would be permanent. The presidential ad hoc task force would be staffed by the president's office. The charge would be defined by the president. It would be filled by presidential staff. Our committee is permanent, and it gives people a place to go with every other proposal. And I guess my closing point is just the perfect can always be the enemy of the good. And I would like to put my 2 cents in before we move on to a vote eventually, that this is a good proposal. And I would ask that you not have some sort of perfect idealized solution that will solve all problems. This is an incremental step that makes it easier rather than harder for everything that comes afterwards. And that was our purpose and objective in making the proposal. Thank you.
All right, thank you, Scott. So there were a number of hands, but only one who I believe has not spoken before, and in view of the time limitation, I would call on Olivia Krull.
Thank you. I just wanted to clarify some of the earlier comments made by members of SDS and UMN Climate Strike. I myself am a member of SDS. I just want to clarify that our criticisms about the composition of the committee were not directed at necessarily the composition of the authors themselves, but rather the fact that there is no ensured mechanism for this committee to essentially not just be an elected body of white students. And so when there are other proposals that have been discussed at previous meetings, which have ensured mechanisms like designated spots for representatives from cultural groups on campus. We just see this as, really like lacking a mechanism to make sure that we actually see proper representation being ensured. And also, I just want to clarify, right, that, we're really concerned about the lack of consultation with undergraduate students on this proposal, specifically our requests, as well as the requests from MSA members who are drafting other proposals were not answered by authors of this proposal. And so, you know, a vote today of no, I just want to echo the sentiment that a vote today, no, does not mean that this proposal cannot eventually pass, but that we would definitely like to see more consultation happen before it is passed. Thank you.
Jeanette, please
All right,
load slide
thank you.
7.
No, I'm sorry, Scott. We've run out of time. I will review where we are in terms of the procedure. This item was on the agenda for discussion. If there is no vote at all, it will be referred to the Senate Consultative Committee for additional consultation with affected constituencies, with an eye for bringing the matter back at another meeting, possibly another special meeting later this summer. If there is a vote, a reminder, 135, which is an absolute majority of the number of voting members of the Senate, a vote of 135 is necessary to approve. If a majority of those present, but not 135, are vote yes, it will have to be put, it can come back in its current form before the next regular Senate meeting under the Constitution, and that would be in the fall. If we do take a vote and it is defeated, of course, as in other circumstances, new proposals could be brought through the committee structure. And as noted earlier as well, no amendments are possible, although of course no amendments were formally offered today on the floor. Amendments are possible later if there's a consultation process, but not of this proposal. Having laid that out, I would ask if there is a motion to bring this to a vote today.
I move for a vote.
Point of order. Point of order.
Yeah.
Yes.
It's unclear to me if and how we have terminated discussion and if there will be further opportunity for discussion or debate. I know that we have a time where we say we're going to be done, but unless someone calls for the order of the day, I think it has to be a motion to call the question or terminate debate. This is a really important deal. This is a big deal. This is a bylaw change. I think that we need to talk as long as the body is willing to talk.
I believe, I'll get some advice from the parliamentarian, but I believe when the agenda item is done, that it is appropriate to end the discussion unless the body affirmatively decides otherwise. We've had an hour of debate, and I received a motion. There was a motion made to vote. And I ask if there's a second.
Second.
We have already had the discussion on the item, and I've reviewed the rules for what the result will be. So I will ask the clerk to provide the a poll. It is a recorded vote in terms of numbers and votes by senators. So I would ask the clerk to bring up the poll on approving this bylaw amendment.
Point of parliamentary inquiry or point of order. Should there be an abstention option on this vote?
I can't formally answer that. I think abstention would be by not voting.
Got it. I think it might be in these kind of cases, I'd be in favor of them being recorded, or the abstentions being recorded, but I understand that we're in the middle of it. So thank you.
Thank you. Thank you for understanding that. If we were in person, obviously, it would be easier to make that adjustment.
I'll give about 10 more seconds if you wish to vote. the last call. There being 80 ayes and 85 nays, the motion does not prevail.
Thank you, Chris. As I noted at the outset, this may be further considered. I think we all heard a lot of support for grappling with these issues and further discussing them today and in the future. But this particular bylaw proposal has been defeated. That is the last item on the agenda. So I would entertain a motion to adjourn.
Madam Chair, I would like to be recognized.
For what purpose?
I would like to move to suspend the rules to amend the agenda and add an additional, let's say 15 minutes onto this meeting for discussion of the previous business.
I believe the vote has been taken, so it is too late for that.
I mean, I'm moving to suspend the rules in order to suspend the rules in order to bring back that business, which I am allowed to do.
I am getting some parliamentary advice. I think the vote has been taken. The agenda is complete.
But we've not adjourned. So this is a motion from the floor. Like we're currently in session, and as a senator, I can make a motion to add business to the agenda by amending the rules. Is that not correct?
All right, we're going to take about a 3-minute break to deal with the parliamentary questions. Really, we're just trying to do this right and appropriately, so give us a moment. We'll take a pause on the meeting and be back shortly.
May I make a point of information? Carol, may I ask you a question?
We've suspended the meeting for a moment, so please bear with us.
So on.
Shit.
Okay, thanks for your patience. You all are testing our chops on parliamentary procedure and order and process and all of that. My best judgment is that there is a motion to suspend the rules to allow further discussion and perhaps to reopen the matter, although it was voted on, in the interests of not trying to stifle conversation and debate and discussion that the body wants to have. I will consider that motion in order, and it will first ask for a second.
I would actually first like to briefly amend my motion because 10 minutes have already passed. I would like to amend my motion to read until the consideration of everyone who has had a hand raised is completed. So if anybody had a hand raised or dropped it, that they would be able to be recognized before the meeting is concluded. Thank you.
And I see three, I saw at, and when you amended the motion, I saw 3 hands raised. So you are asking for a suspension of the rules to permit
that we voted. So I don't know if these people still want to speak, but I would say that until everyone who wanted to speak has had a chance to speak, that we not move to further business items.
There are no further business items.
Well,
but
yes, that's what the next business is, adjournment. So that we not adjourn is what I'm saying.
All right, so your motion is to allow those who, I think it will be hard for us to know who had their hands up. So
yeah, I'm just expecting that everyone who had something to say, raises their hand and says it. It's not important that the specific people are the ones who are raising their hands.
Right. I will entertain a motion to suspend the rules to permit further discussion to allow people who raise their hands quickly, it's an unusual motion, to speak. It's not debatable, I believe. Did I hear a second?
I asked for point of information.
What is your point of information?
Is the vote total official? Has it been checked to the Senate roster?
I will ask the clerk to take a moment and respond to that. We'll come back to that point of information. Did I hear a second?
You did. I second the motion.
Okay. It is not debatable. So if on the assumption that it perhaps matters to some in their vote, I will ask Chris to confirm if he can say the vote total is not yet official. I think the numbers, well, that was percentage, sorry. It would take about 20 minutes. So we cannot absolutely confirm, but the numbers. Perhaps he can say how many votes there were on each. My memory from the
it was 80 to 85.
Yeah, the one thing I can't confirm the overall. It just takes time. I have to go through the register, and the meeting has to end. But it did not reach that 135 threshold. The ayes did not hear that 135 threshold.
Right, and the only question I believe is whether they are senators or not, but with only 80 aye votes, it is clear that it will not have passed. So there is a motion on the table to suspend the rules and extend the debate. This requires a 2/3 vote. It is not debatable. So I would ask the clerk to pull up a poll on whether to suspend the rules to permit further discussion of this item.
give about 10 more seconds for all those who wish to vote. And last call. There being 55 ayes and 86 nays, the motion does not prevail.
All right, and before I ask about a motion to adjourn, let me repeat that this has been a long and robust discussion, and I believe it will continue. It will continue in the Senate committees, and I'm sure we will be continue to consider these issues. It's an important venue for this discussion, and I appreciate everybody's participation in it. I would ask then if there's a motion to adjourn.
Motion to adjourn.
Second?
Second.
All those in, thank you. All those in favor?
Aye.
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 I think we'll have a poll.
About 10 more seconds if you wish to vote. And last call. There being 125 ayes and 9 nays, the motion prevails.
Thank you. As I adjourn, I wish you all a healthy and safe summer until our next Senate meeting. Bye-bye.